Welcome to the Legacy Cast by Kelley Legacy Law.
Hello and welcome back to the Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. Their practice focuses on helping families enhance their lives today and secure their futures tomorrow. My name is Kevin Rosenquist, and today we're talking about what happens if you can't make decisions for yourself and why incapacity planning is one of the most overlooked but essential parts of every estate plan. Michael, welcome.
Hey, thank you so much for having me, Kevin.
Could you start by explaining exactly what incapacity planning entails for families?
Yeah. A lot of people, they think about passing their assets along when something happens to them, but they don't really think about healthcare planning that much. Or if they do, maybe they've heard about a living will or something, or they've had surgery before. You have a DNR, do not resuscitate, but that's about the extent of it. So what I tell people with incapacity planning is it's just so important for you to be able to name the people that you would want to make decisions for you if you can't make them for yourself. And we have plenty of examples we can share with people on, things that have gone badly when there was no documentation in place. We talk about just in general, your financial power of attorney. A lot of times it's called a general durable power of attorney. We talk about a healthcare power of attorney, which I do is a separate document from a living will, which is also called an advanced healthcare directive. And then we also do HIPAA documents as well for our clients when it comes to, the potential need to get medical records for somebody. So that's the general, framework.
I think it's a common thing for people to just assume their spouse or adult child can automatically step in if something happens. Is that true?
Unfortunately, no. Now, am I saying that some nursing home won't let somebody sign for you? Maybe, but legally they're not supposed to. And it's really dangerous to not have documents in place. For example, I had an 87-year-old man that was married to this, his wife was 85 years old. They'd been married for over 60 years. She had severe dementia, was having an episode, needed to go to the hospital. They called the ambulance and the EMTs got there, and she was refusing to go because she didn't know what was going on. But she was very irate and angry. And they said, look, we can't take her to the hospital while she's saying no if you don't have some kind of power of attorney or something like that. So they literally had to wait for her to be sedated before they would take her. Then we had a situation where he wanted to transfer her from a facility, in one part of the state to a facility where I am. And we had to literally file an emergency petition for guardianship to get this man appointed for his wife, guardian, just so he could move her from one facility to another. We had to have a hearing. Wow. The court had to appoint a guardian ad litem to represent her interests, to go evaluate her, make sure she was, in the condition that we claimed, et cetera. And it was costly as well. So, that is about as good of an example as I can, give anybody about something that should have been very easy for a husband to do for a wife. And we had to go through all that headache and heartache so he could make those decisions.
Yeah, the emotional toll in that situation. I mean, not only is he already dealing with the person he loves deteriorating mentally, but then has to deal with that on top of it. Just makes it all much more difficult.
Yeah. And it can be a costly and a time consuming thing as well. So nobody wants to go through that when they're dealing with the emotional aspect of it. So getting documents is crucial.
Can you talk about the difference between financial power of attorney and a healthcare power of attorney? Because I feel like that typically that can get kind of confusing.
Yeah. And those are two totally different things. Some attorneys or online, forms that you can get, they'll combine those things. Sometimes there'll be maybe, it'll be called a general durable power of attorney, and there'll be one paragraph about healthcare in there. It's way too big of a thing for me to do that. I like to separate those things out. The financial power of attorney is essentially naming somebody that can do anything financially you can do for the most part. So if you become incapacitated, as that is defined in your state, you can have that person step in and make decisions for you. Now, it's a little bit different than a healthcare power of attorney too, because actually a financial power of attorney, you can give somebody power to act for you immediately upon signing the document, even if you're not incapacitated. So You can give somebody like your spouse, for example, the ability to sign a car title or a deed or, contract or, for you or something like that. But also you can create what's called a springing power that is only effective if you become incapacitated. So that document gives some flexibility. And it kind of goes hand in hand with what some people may have heard of as a conservator. So like if you don't have a financial power of attorney and you become incapacitated and we have to go to court to get somebody named, a conservator is who's going to be named to handle finances. Okay. The healthcare power of attorney, on the other hand, is only going to be used if you can't speak for yourself. Okay. So there is no immediacy thing there as far as that goes with healthcare. And that's going to be, at least the way I do it, separate from a living will. So our healthcare power of attorney is going to cover everything healthcare related, such as choosing doctors for you, check you in and out of medical facilities, rehab facilities, getting your medical records, long-term care and hospice, pain management, etc. And this person would be your guardian of your body if one needed to be appointed for you. So financial stuff, we have a conservator. Healthcare stuff, we have a guardian. So those are the major differences.
Okay. The HIPAA release form, something that kind of gets overlooked a lot when it comes to estate planning. What exactly does it do, and how can not having one create problems in a medical crisis?
Yeah, HIPAA is one of those things that's always fascinating to me. I used to be a litigator, did personal injury cases and things like that. And doctors and the doctors' offices are terrified of HIPAA, like violating HIPAA, like giving out your information, violating your privacy, and violation of HIPAA. Honestly, the HIPAA law itself doesn't have a lot of teeth to it that could cause you to be held accountable if you're a doctor, but that's a discussion for another day. We include it, though, in our healthcare power of attorney, and then we do a separate HIPAA authorization so that family members can get medical records quickly if they need to, if we do have a situation where someone's incapacitated, or let's say even, for example, we're doing an estate plan for somebody and maybe they've had some memory issues. I can even get, the ability through a HIPAA document to request their medical records to check on their mental competency in order to do that. But for family, it's just crucial to be able to get those records quickly so that, doctors can find out, what's wrong with somebody, what their history is. We can do that as quickly as possible. And honestly, we don't want to think about this aspect of it that much, but when somebody dies, we can actually, in our HIPAA document, give our family another 2 years after we pass away to be able to get our records in case there's some kind of medical malpractice lawsuit or personal injury case, wrongful death case where they need to get our records. They can still get them without having to go through a longer process. So the HIPAA document is something that the doctor's offices are not ever going to bend on, something that's very easy to get in place and crucial to have.
When you walk clients through choosing an agent or a decision maker, what qualities do you kind of encourage them to look for?
Well, I mean, when it comes to a financial power of attorney, obviously somebody that you trust implicitly, because, if you give them the authority, they're going to be able to go do things like, take money out of your bank account, open a credit card in your name, deal with life insurance, maybe even deal with your, brokerage accounts or retirement accounts. Depending on how much power you give them, they may even be able to change beneficiaries or make, gifts to people. If you have a living trust, they may be able to amend that trust. So there are a lot of really powerful things that a power of attorney can do. So you want to pick somebody that you trust implicitly. If you're going to give them an immediate power, if it's only upon incapacity, then you feel a little bit better that, hey, this document's not going to be used right away, but if I have to have somebody do it, then I at least have named somebody to do it. So that's what I would say. Trustworthiness, and a lot of times when we have families that have multiple children and they're living all over the country, you have to take into account who lives close by. Sometimes they may name a child as their primary agent because they're around and they can get access to things, to get things done. Whereas another child that maybe would be better with money, maybe they'd be a higher, choice on the totem pole, but they live in California and we're in Alabama, then it doesn't make sense to have them because named higher, because they won't be able to, carry those things out. So those are really kind of the top two considerations when we're talking about choosing agents.
I think there's a lot of, obviously there's a high temptation to go online and try to download powers of attorney documents, other types of documents. Obviously AI is a big deal now. People are asking ChatGPT everything. What tends to go wrong when someone takes that route instead of having it prepared correctly through Alabama law?
Yeah, it's one of those things where how much peace of mind do you want that your document's going to work for you when you need it? The balancing act, people may assume that just because they're getting it online, that whoever's, created that software or that website or what have you has done all the homework about, what does and doesn't work in their state. And that may not be the case. Most of those online things have a disclaimer at the bottom that says, this is not a substitute for legal counsel. So they're covering themselves. They're just selling documents. They're not selling advice or expertise. So, that's the first thing to consider. How much, is there that maybe you just don't know? You don't know what you don't know. So,
Sure.
And every state is different. So, in Alabama, statutory power of attorney is going to reference Alabama statutes. Okay. Well, what happens if you're out of the state? You've done an online form and now you're in Idaho. Is your Alabama power of attorney going to be effective, or should you have done, maybe in addition to the state statutory form, maybe you should have done a general one that's applicable in all 50 states to the most of our ability to do that. So those are the kind of things that I think a lot of people just don't think about. And honestly, just knowing what you need. The example I gave you earlier about the gentleman that, was 87 years old when we had to get named guardian for his wife, he had done a will online. He'd done a last will and testament online, but he did not know that he also needed to do healthcare incapacity documents. So, there was nothing to prompt him to do that. Had he come to see me, I would have said, okay, your will's great, and here's all the other things we need to do too. So that's why I caution people about doing the do-it-yourself stuff. It's just such an odd thing. I don't really know of any other areas in the law where it's just presented to the public like, oh yeah, you can go do this yourself, no big deal. Most other things it's like, oh, you got to have a lawyer, right? But
that's a good point.
A lot of times it just comes down to you get what you pay for, and will it work if you do it yourself? Maybe not.
Have you ever tried to go onto one of the AI platforms like ChatGPT and just see what it came up with out of curiosity?
Well, interestingly enough, I actually use ChatGPT quite a bit.
Yeah, me too.
To just, hey, give me the pros and cons of if I make this decision or that decision, or, what's best practices if I'm doing this. Or sometimes I'll take a clause from my documents or a clause that I custom draft, and I'll throw it in there and say, hey, what does this clause mean to you? And let it tell me how it interprets, maybe to make sure that, it's just double checking things for me. But
yeah,
I've never gone on there and said, hey, draft one of these forms for me. But even if it did, anything that I pull from there, I'm clicking on the links to see where it pulled the information from and make sure that the source material is good, because I have used it before where, I used it to calculate something and it gave me one number, and then I went in and I reworded it and asked the same question a different way, and it gave me a totally different number and a different calculation. So a lot of attorneys have gotten in trouble, and there's been a couple of big cases here in Alabama where attorneys have used ChatGPT to draft briefs for them that they filed in court. And then
yeah, I've heard of some of those stories.
When the clerks went in and pulled the cases that were cited for these, certain assertions, those cases did not exist. And ChatGPT had just made them up to try to answer a question. So, I'm sure it's going to get better, but it's just as good as the source material. And, it may not give you the same answer 2 times in a row. So I wouldn't rely on that. And honestly, I've had some friends that have started businesses and gone to ChatGPT for releases that they want people to sign and non-disclosure agreements and things like that. I can read them and tell that they came from ChatGPT. So you just have to be very careful. It's a good tool, but it's not the end all be all.
It's a tool to help, not to draft final
Right.
documents and things like
Right.
that. Yeah, totally agree. For parents of college students or young adults, should they consider having incapacity documents, even though their kids are presumably healthy and independent?
Yeah, no question. Actually, we do here. I'm in a college town. Auburn University is here. It's a big college town, and I do what we call our college kids plan, and I've done several of those. So, Alabama, the age of majority is 19. Most states it's 18. But once the child turns that age, the parent's not going to be able to make decisions for them anymore. So if they're in a car wreck and they're on life support, or something financial comes up, you're cut off as a parent, and that's a crazy thing to think about, but that's the reality of it. So I actually just did a plan for a 25-year-old whose parents live here in town and is going to be moving away, but had no incapacity documents. So we got all those put in place for them. But yeah, it's a crucial thing, and it's not, the full blown estate plan like we do for married couples and with all the assets and children and things, but it's at least a very simple, healthcare power of attorney, living will, financial power of attorney. Depending on age, if they have some small assets, maybe we'll do a last will and testament, a basic one to go along with it. So most people don't think about it, but it's an easy thing to get put in place. But boy, when you need it, you're glad you have it.
Yeah, that's something that people don't think about, especially because you've been in charge of your kid for their whole life, and then all of a sudden you're not anymore. And you don't think about that. I mean, you realize that if the kid's 35, but you don't realize that when your kid's 19.
Well, let's face it. I mean, a 19-year-old today is different than a 19-year-old in the 1940s. I mean, they're still kids for sure, maybe even up into their late 20s at this point. So, we definitely, and we have laws, you can stay on your parents' insurance until you're 23, 26. I can't even remember, like health insurance. So, yeah, it's important because a lot of young people are not ready to be able to handle those things on their own, even though they're technically an adult.
How often do you recommend people look at their plan, update their plan, consider any sort of changes? I imagine certain big events, marriage, divorce, that kind of stuff, but is there a general rule for how often you should revisit?
Well, yeah, I mean, like you said, any major life change, if there's some big change in the law, depending on the kind of assets you have, your family structure, your net worth, if there's a new tax bill that comes out or, something like that you hear about on the news, it's always good to check and see if that's going to affect your plan. But just in general, as a rule of thumb, the way we do things for our clients is, okay, if you initially do a plan with us, at a minimum, we will meet with you every 3 years to go over your plan and see if anything needs to be updated or changed. So, we have a family care program where it's an annual thing. If you want to be a part of that program, where we'll go and have a meeting annually with our clients to go over things. So, but at a minimum, I'd say 3 years. And especially when it comes to incapacity documents, like we're focusing on here, a lot of your banks like to see a power of attorney that's less than 3 to 5 years old. They like to see those things updated. Healthcare, different forms come out. Something you executed 20 years ago in Alabama, the form we have now is different. So you want to keep those things updated so that when you need to use them, the doctors or the bank or whoever, it's something that they're used to seeing, that, they can go ahead and approve, because a lot of these places will have a legal department where they want to send your document to be approved to cover themselves. So we need to have those things updated fairly often.
All right. Well, thanks for joining us on the Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. To learn more, visit KelleyLegacyLaw.com, and don't forget to subscribe to our channel. Leave us a review. We really very much appreciate that. Michael, really appreciate your time. Thanks so much for being here.
Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.